adjusted. Yes, Mr. Pranjadev, take a fresh memo.
Yes.
Kindly give your memo. Kindly give your memo.
Yes. Contempt.
Contempt assignment अच्छी तो?
Yes, your lordship से.
ठीक है, assignment अच्छी ठीक है. और एक मिनट. Registry को दे दे assignment ठीक है.
May I please, Your Lordship?
Yes, please.
In item number 15, seeking an adjournment because family matter.
Just one second. Go page wise.
Okay, Your Lordship.
Page 1, 1 to 7.
My lords,
The next page, Russian.
Page 2.
item 9, my lords.
Yes.
My lords, I have received the counter. My rejoinder is otherwise ready, my lords. Certain factual aspects need to be brought across. May I pray any other day, my lords?
Not a date करते हैं. सुबुची, अपन सुबुची तो. सुबुनी. Item 9 mention करते हैं. Yes. और एक बात करो. We commence in कोडिंग चारे.
My lords. Oblige, my lords.
Microphone on करना. Yes, next. 10 to 18. You mentioned 15.
May I please, Your Lordship? Item number 15, seeking an adjournment. As it's a family matter and there are chances of amicable settlement.
But it is listed for orders. You have to take steps. By adjourning item 15, nothing is achieved. It is listed for orders to file application.
Your Lordship, the opposite parties has not appeared yet.
Kindly look at whenever you are
Yes,
submitting, always read
Yes,
the cause list.
Yes, Your
You
Lordship.
can use the paperless also. What is the office note in the paper 15? It's
It's not.
You'll assist. That is meant for you only. You are Amrita.
Yes, Your Lordship.
Yes, please. So kindly mark this case may be registered as CRLMP regarding these steps. These steps not yet taken.
Yes, Your
So
Lordship.
after 4 years, suppose I adjourn the matter, you must understand. So
Yes, Your Lordship.
regarding opposite party, when you are saying unless the matter is registered, nothing can be done.
Yes, Your Lordship.
So you do the needful. You take time.
Your Lordship, I'm taking time for registering this matter and preparing for admission. Can you give in a short date?
So what information I could not get you? Could not hear you actually.
The matter is not admitted yet, I believe.
No, it is defective.
Okay,
This
Your
is
Lordship.
defective
I'll take
application.
steps.
You have to take steps to cure the defect.
Yes, Your Lordship, I'll do that.
Okay. Let's come to item 15. This is Amrita Misra. You continue your maiden name Misra also.
Yes, Your Lordship.
Yes. This is Amrita Misra for the petitioner. Though the matter is pending since 2020-22. Though office note put up by the registry indicates staff report dated. This staff report ki handwriting kebe bhi padhi honi kon election. Upon kon and se type kariye kon se kon 30 no 22 sedino date upon kale out date mu कहली गोटे आपण गोटे date तारिणी नायक तले लिखा है 30 no 22 ओके जब कौन लिखले नहीं सेटा तल सेंटेंस चेंज करे ऑफिस नोट पुट बाय द रजिस्टर इंडिकेट्स मुडे द स्टाफ रिपोर्ट डेटेड 30 no 22 indicates that the nomenclature of the petition is not correct. Correct nomenclature may be CRLMP. The learned counsel for the petitioner has adjournment to do the needful. Suppose in case you are not having any instruction, because I think you are not getting instruction. What is the updated case or which?
Yes, Your Lordship.
So that's why you can file no instruction or whatever. I'm giving some time to do it
I will
faster.
seek time to correct the defect.
But first you talk to the person.
Yes, Your
What is the
Lordship.
status? Because these are in the interlocutory application.
Yes, Your Lordship.
Phone padiyola. Has adjournment to do the needful. List for orders in the week commencing.
30
Tiristin.
Much obliged, Your Lordship.
Yes. Next page call kar.
19 to 24. Page 6, 25 to 29. Page 7, 30 to 31.
Please. 30 sir. 30 ko le.
This matter, another matter fixed on 14th April. Same to be fixed. Similar matter
14th April before this bench.
before this bench.
Week commencing. 14 April ছুটি আছে।
We commencing 14th April. Perhaps.
30 টাକୁ week commencing 13th ରଖି ଦିଅନ୍ତୁ। ଆପଣ ସେ ନମ୍ବରଟା ଲେଖିକି ଦିଅନ୍ତୁ ଚେକ୍ କରିବେ ନହେଲେ ସେ ଜାଣିପାରିବେନି। ଆପଣ ସେ ନମ୍ବରଟାକୁ ଲେଖି ଦିଅନ୍ତୁ if it is there so we can do something.
Yesterday,
ଦେଇଦିଅନ୍ତୁ।
obliged.
Yes. Any other matter? Please.
Item number 2.
I'm just starting.
Item number 1.
One.
Although
Yes, that's for the petitioner. Yes.
Although this matter could be reconcilable and could be sent for mediation, unless we take the consent of the client, we haven't been able to take the be in contact with the client. So we have written a letter to the client today morning. Lordship may keep it for give it some time in order to obtain instructions as to whether it can be.
What is the nature of order in CP?
This order was rejection of the petitioner's application under section 10 of CPC. The petitioner has filed an section 9 petition under Hindu Marriage Act in the Puri court, whereas the opposite party had
They have
filed.
gotten instruction also.
Yes.
Maybe the cause of action would not survive.
Yes.
The matter is listed under the heading so and so. Yeah. The application was filed in the year 2010. The writ application was filed in the year 2010, challenging the order dated 27/1/2010 passed by the learned appearance Miss Sadha Das for the petitioner, opposite party blank. Apare कौन election देवे? Learned judge
Family court.
Family Court Rourkela in CP number 198 of 2009. Rejecting the prayer for stay of proceeding.
Yes. Under section 10 of CPC.
Okay, stop. It is submitted by the It is submitted by the learned counsel for the petitioner that she is trying to contact the petitioner to obtain up-to-date instruction in the matter, and the matter may be adjourned. None appears for the opposite party. The matter shall be listed in the week commencing 6/4/2026. The next date of listing shall be intimated to the learned counsel for the opposite party on record. Stop. The registry shall also obtain the status of the CP number 198 of 2009 from the Court of the Learned Judge Family Court, Rourkela, and status of the CP number.
So that was a MAT case.
Just one second.
The other case, MAT
Status
number
of the
471 of 2008.
MAT case number 471 of 2008. Then pending before the Court of Civil Judge Senior Division, Puri. From the court in session of the matter. In view of the fact that the Court of the Family Judge Puri has been established, the instructions may be obtained from the Learned Judge Family Court, Puri. Date tell dictionary. So last two lecture. Yes. Next.
Item 2.
May I please, Your Lordship? On behalf of Mr. K.A. Guru, my Lordship, the writ petition is infructuous and liberty may be granted to withdraw the petition.
So please file the memo signed by Mr. Guru.
Yes, sir. Yes.
The matter is listed under the heading so and so, so and so. The petitioner husband is before this court challenging the order dated 2/3/2010 passed in CP number 198 of 2009. By the Learned Judge Family Court, Rourkela. No, sorry. On your file would have been. Petitioner husband in the marriage is before this court challenging the order dated 12/4/2017 passed by the Learned Judge Family Court, Dhenkanal in IA number 6 of 2017 arising out of CP number 94 of 2016. The CP number 94 of 2016 was filed by the CP number, these are the instant husband in the marriage under section 13 of the Hindu Marriage Act, which was transferred from the Court of Jurisdiction at Delhi as per the directions of the Honorable Supreme Court to be tried before Dhenkanal. During pendency of the CP, IA number 6 of 2017 was filed under the section 24 of Hindu Marriage Act. Under section 24 of Hindu Marriage Act, which was allowed. Today, the matter being in the list memo of date is filed by the Learned Counsel for the petitioner. states thus: the memo shall be taken on record, scanned copy be updated, the petition stands disposed of, copy of this order shall be forwarded to the Court of Learned Judge Family Court Dhekanar to be kept in the records of CP number 94 of 2016. Bracket रे लिख देवे. Yes, next please.
Item 3,
None appears for the petitioner when the matter is called. Matter is listed under the heading so and so. The matter shall be listed again under the same heading in the week commencing
6/4.
6/4. जोड़ा किसी आसी जिबे आपण सेटा appearance टा करदो. Non appearance टा ट्राई करते.
Item 4,
आपण सेम सारे करिके so and so appearance खाली adjournment कर दे. Or Mr. Sahoo, Mr. Rabindra Kumar Sahoo for the petitioner. Yes,
Can be formula. I am agreeable to
one thing.
take instruction.
The matter is listed for under the heading एठरे आपनकर acquisitioning authority जे पैसा देबे पार्टी अछंती तो
Again,
से की with
land
authority
acquisition zonal officer.
sir
Land acquisition zonal officer.
अरे से पैसा देंती नहीं आज्ञा से acquire फीस स्टैच्यूअर आपण जदी कोर्ट को पार्टी करियो धरंतु रेफरल कोर्ट को से पैसा कोठु देबे मीडिएशन का भीतर हबो हस्बैंड एंड द फैमिली जज वाइफ एंड द फैमिली जज सेंती परियो मीडिएशन करियो
नहीं नहीं
कि एक्वायर किए कले किए पैसा देले आपण ऑफिसर को पार्टी कर देले
I will make it.
and this order is illegal. Constitution bench or the larger bench decision of the Supreme Court, when the acquisitioning authority is not a party, where is railway is a party who has not been made a party? Khurda Balangir new broad gauge line link project is made by the railway. Whichever company, East Coast Railway or the construction company, he is not a party before the learned court.
Not. You put the whole learned code below.
The matter is listed listed on the heading L. Noticeably, the authority for which the land has been acquired is not a party before this court, nor it was a party before the learned referral court. That is, learned referral court stop. The authority no ki. The land was acquired for stop kar dele to. The land was acquired for the Khordha Balangir new broad gauge rail link project Balangir. The matter is kept pending since 2015. The matter is pending since 2022, arising out of a reference of the year 2015. Foreign notification केबे हितला
Notification dated 7/5/2007.
कोड पहले सेटा को पेज रे अछि
First page, first paragraph.
पेज 1
And page 2,
माने आपण गवर्नमेंट ने ऑर्डर कॉपी रे
my averment.
गवर्नमेंट नियंत्रण ने आपण ऑर्डर कॉपी देखा नेक्स्ट वन जजमेंट देखियो ना अच्छी
अच्छी।
पार्ट 5 रे
Findings.
और उसने
Findings. Paragraph. Paragraph 5.
The land acquisition was pursuant to the notification number 17614 dated 7/5/2007, published in the Gazette on 11/6/2007. in view of the judgment rendered by the Supreme Court in so and so, also followed by this court in so and so, the requisitioning authority, that is the railway requisitioning authority oblique project proponent for whom the land has been acquired has to be heard for determination of compensation as well as enhancement of compensation. Reasons best known before the learned referral court, the said authority was not made a party. The land acquisition zone officer, who is the statutory authority under the Land Acquisition Act, acting as the authority for disbursement of the land acquisition compensation as deposited by the project proponent, is the only opposite party. The project proponent has not been heard by the learned referral court. से कोटी प्रोजेक्ट प्रोपोनेंट रा कोटी माने आपन को रेफरेंस से किछि डब्ल्यूएस फाइल बेनी
WS
जा कहबे से तथास्तु कहबे ना कोन डब्ल्यूएस ता कोटी आसला के फाइल कले कोन कोटी डिस्कशन हैला बर्तमान धरन मते लागुची से पाइबा कथा एबे केते 5 लाख पाउछथि मु कहबे से 6 लाख पाइबे कि 10 लाख पाइबे कोन तथास्तु करिबि ना नै डब्ल्यूएस रे किछि का पचारि कोन करिबि
that has been discussed.
कोटी डिस्कस है after 19 years, we are searching who is the opposite party and where is the WS. In such scenario, in absence of the project proponent who is to pay the compensation to the appellant, the matter cannot be referred to mediation. और जदि कहबे it will be remanded back again to hear the
Remand.
अपना
Party agree करो.
केबे केबे आसिले हबो मु आजि कहूनी आपन को because I am not in a hurry to go disposal आपण एई पार्टटा कंसीडर करन आपण एटा काहे कि 22 मसे रु पडिछि सेठी भी से माने the court the referral court under section 18 what it has adjudicated आपण पाइले कि मिस्टर मानती
No. Yes, Mr. Sahu, you want today disposal or some other day you'll go through those judgments? I'll give the judgments. Because when I am considering a matter, I have certain things in my mind, my understanding, reading. So I'll say, so you go through that. Still, whether you can sustain a appeal and a reference without impeding the party who is paying the money.
The party, he has to be made party. Your lordship may remand the matter. He may be made a party there.
कौन लिखते ते आप जजमेंट गुडा लिखते तापर एबे कोन सेंटेंस टा कोड सरला पर regarding the absence of the project proponent
before the learned referral court when the proceeding was undertaken under Section 18 of the Land Acquisition Act 1894 cannot be improved upon at this stage in the appeal. Therefore, the matters is the order dated 5/8/2022 is set aside. The LA case number 19 of 2015 is restored to the file of the Learned Senior Civil Judge Balangir. Stop. The order shall be communicated to the Learned District Judge Balangir for assigning the matter to the court of jurisdiction who can take up the matter at present. The learned court that will take up the matter shall pass orders impeding the project proponent. Or project proponent ki jani chandi ki actually. I was trying to find out who is the project proponent.
Railway ଅଛନ୍ତି ମୁଁ ଯାହା ବୁଝି କହିବି
Rail Vikas Nigam Limited or this Khurda Balangir. Usually what they are doing, they are making a special purpose vehicle. Like I'm not sure, Khurda Balangir Railway Company Limited. So they are doing it. Only. Entering no, impeding the project proponent as the opposite party. They'll issue notice to the project proponent as well as the land acquisition officer and take up the matter. Stop. It is also requested, the learned court is also requested to take up the matter expeditiously as it is the cause of action. As the LA case number 19 of 2015 is now restored to file after 11 years. Original certified copy as for rules. Decided cases list अच्छी की सेठी अच्छी. This is how you will get that. I'll refer to that Supreme Court decision. Yes, next. Disposed of.
Madam, I
May I please,
Your Lordship.
Yes, please. Your name, sir?
We sought for some instruction. So kind
आपका क्या नाम है, sir?
2 more weeks, please.
What's your name, sir?
PK Naik.
Mr. PK Naik for the petitioner.
Well,
On 28/1/2026, the matter was heard at length. And the learned counsel for the petitioner had adjournment to obtain instruction. As observed in the said order dated 2/3 in the said order dated 28/1/2026, 28.01.2026, paragraphs 2 and 3. So today, the matter being in the list, adjournment is sought for on behalf of the petitioner to grant further opportunity. List in the week commencing 6/4/2026. Yes, Mr. Mahanti, Mr. Biswambar Mahanti for the petitioner.
Item 6.
This insurance is in my determination.
My lord,
Insurance matter ta wo.
order passed by the permanent local Adalat.
Acha, the local. Okay.
Your Lordship, in last occasion directed to go through the judgment 2008 Supreme Court.
All. So
Where
what I am doing after hearing all of you, I am issuing notice keeping the question of maintainability and admissibility open.
Yes, yes, my lord. But I also brought to judgment of where the Honorable.
Because yesterday also the same thing happened. No, which judgment you have signed?
My lord, Canada.
Bhanti, what is the question asked to you? Then you say, what is the question you have understood I have asked you?
The Lordship has to go through the judgment 2008 Supreme Court regarding the order passed by the Honorable Supreme Court under Section 19C. The order of the Lok Adalat, where your Lordship has referred the matter 2008 Supreme Court, where the Honorable Supreme Court has decided whether the order passed in the Lok Adalat can be subject matter of challenge in the writ petition or not.
No.
What I have.
My knowledge is not that poor. I will not seek your assistance, then why I refer to the decision? Writ petition is maintainable. But to maintain a writ petition, what are the conditions?
That regarding the.
So you have to satisfy that what you are saying, because for disposal of a matter in Lok Adalat, lot of effort is made, lot of money is spent, lot of effort is there. So the conditions what are indicated in those Jalor Singh, then subsequently the other two decisions. Writ application, even appeal is maintainable. If you read the decision, I was discussing yesterday also, in certain cases, appeal is maintainable.
My.
So maintainability of the writ petition is not an issue. Writ application is definitely maintainable, but entertaining on what grounds? Because after the entire effort is made, we are also involved in making Lok Adalat, DLSA, SLSA,
That is
High Court Legal Services Authority, Supreme Court Legal Services Authority. Then in one second, I interfere and stay order. So then at least prima facie you have to make out a case before this court.
No.
Yesterday one case, Mr. Lenka was arguing, they said that it is our property. Then when I asked that where you have stated on oath that it is your property, then I am asked that you issue notice, they will say. So here what is you are saying that you are not being heard.
No, I am not saying that. On the merit, the matter has been decided. On the ground of limitation, the permanent Lok Adalat has denied my claim, my lord. This is against the insurance company, my lord.
So then it is a clear case where you can approach in writ petition.
Yes, ma'am. This is on the ground of limitation.
But anyway, I will note that those. You are the claimant there. Your case has been denied. So also you have to challenge it. So this is a clear-cut case.
That's why
But where the third persons are saying that Mr. Mahanti's property is my property. I have not been made a party.
No.
Then I ask that you file affidavit.
No, that is not my case.
Then the reply is that you issue notice to Mr. Mahanti. He will say. You must understand that
My case is
a lot of effort is made. To persuade an insurance company to agree for a settlement is really Herculean task. While it is much easier in regular assignment, because we are passing the order, let them challenge. But to persuade, because unless they agree and sign that, you must understand that. So for that only, this is the reservation is that why Section 21, 22 of LSA Act is there. Why the Supreme Court has said that on these conditions only it will be challenged. And in fact, it is there one paragraph. It can be challenged.
Last but one paragraph that is there.
That it can before that. Where appeal is also mentioned. It can be in certain cases, appeal can be maintained.
There is a distinction, Section 19 and Section 21. What I just citing the decision.
Yes.
The Section 19 is the Lok Adalat and Section 22 the power vested of the permanent Lok Adalat of the LSA Act. That has been discussed in this judgment, my lord.
So 22, the normal you cannot challenge. 24 is a bar, I think. Whatever, that's the next section. I cannot exactly recollect. So order passed in 22 attains finality.
Yes.
Then now you can file writ petition.
Yes, madam.
No difficulty.
Yes, ma'am. But under Section 19, if the order is passed in the Lok Adalat, that cannot be challenged. That can be challenged in certain terms, at certain ground. Whether the
22 also.
No,
there is no distinction between which copy you are handing over.
Canara Bank versus GS Jairam.
Citation?
2022 Live Law Supreme Court 499.
Justice Pardiwala's judgment.
My lord?
Justice Pardiwala's judgment.
No, Justice Chandrachud.
There is after that there is another judgment. Anyway, that's not necessary. I'm issuing notice. You are saying that you are the claimant yourself. It is not the case.
I am the claimant.
Usually, third parties are coming here and saying that we are not heard.
On the ground of
Petition has been granted.
ejected.
The petitioner before this court is the claimant before the Learned Permanent Lok Adalat, Puri. She had filed Permanent Lok Adalat case number 48 of 2025 against the opposite party. The Claims Department, India First Life Insurance Company Limited, and another. As well as the banker, Union Bank of India. Had Lorded Counsel. The PLA dismissed the court upon dismissal and limitation page
running page 58, paragraph number 17. In the above criterion,
Just 1 second, I have to get there.
My lord,
I have to get that page.
running page 58,
Yes, I have got it now.
paragraph 17.
Yes. कौन लिख ले? After considering the application of the petitioner, has passed the following order, 17. It is not the case what you are saying. You have not read para 17. Read para 17.
In the above criterion is applied to the present case, it is noticed that the delay was more than 4 years and no satisfactory explanation was given to explain such abnormal delay except the
Read
Ball
slowly so that it will register. Then accept the Boyle statement.
statement that the applicant is an illiterate and ignorant person, as it reveals that the applicant has
That
already
is important. We have received 2 lakhs from whom?
the two policies there. They have given 2 lakhs in a policy. They have released the amount in respect of the 10 lakhs rupees. Now they are saying this is a barred by limitation. Though I have applied for 2 policy and they have not communicated.
कौन लिखे? Para 17 page 52 quote कर दो है ना? It starts with in the above criterion up to applicant is dismissed. It is submitted by the learned counsel for the petitioner that the petitioner had 2 policies. She got the benefit of one policy amounting to rupees 2 lakh. The other policy 10 lakh केमती कौचंती? It was sum assured. 10 lakh कौचंती कौन?
10 lakh sum assured ଗୋଟେ policy.
ସେଟା କୋଉଠି ସେଟା deal ହେଇଛି?
Again, page 50 ରେ sir ଅଛି. The applicant, namely Malijanu, is the son of the
ଆପଣ ଯେତେ ସ୍ପିଡ୍ ରେ ଯାଉଛନ୍ତି ମୁଁ ତ ଆପଣଙ୍କ ଭଳି ଏତେ ଫାଷ୍ଟ ନୁହଁ.
page
You
50.
are leaving me behind actually. First policy, second policy कोड लिखा है?
Sir, page 50 रे
According to the applicant.
award जो लिखा है जी, the applicant, namely Malijanu, is the son of the deceased Mali Apsara. He has
ସେଟା
filed
ତ ଆପଣ ସେଟା ମୁଁ ପଚାରୁନି. ଆପଣ ଯୋଉ ଦିଟା ପଲିସି କହୁଛନ୍ତି ସେ ଦିଟା ପଲିସି କୋଉଠି ଲେଖିଛନ୍ତି? ସେଟା ପଚାର ଯୋଉଟା ଆପଣ now you are contending. I have recorded that.
sir. Paragraph 5 रे page 52.
ପଢନ୍ତୁ. State away said the where you have stated first and second policy.
In order to prove the case, the parties to the application are given ample opportunity to produce evidence in support of the respective claim and to file additional statement and reply, if any. In course of the proceeding, the learned counsel.
ଫାଇଣ୍ଡିଂ କୁ ପଳେଇଲେ.
Sir, the fact
ଆପଣଙ୍କର କଣ୍ଟେନସନ ଆଇଦର ଆପଣ ଲେଖିଥିବେ ପିଟିସନ ରେ ନହେଲେ ଜଜ ତାକୁ ଡିଲ୍ କରିଥିବେ ତାଙ୍କ ଜଜ ଆପଣ ତ ଆମ୍ପଲ ଅପରଚୁନିଟି ପ୍ରିନ୍ସିପଲ ଅଫ ନ୍ୟାଚୁରାଲ ଜଷ୍ଟିସ କୁ ପଳେଇଲେ. ଆପଣଙ୍କ ପିଟିସନ ରେ କୋଉଠି ଲେଖିଛନ୍ତି?
ସେଇ ଜିନିଷ ସାର୍ କିଛି ଡିସ୍ପ୍ୟୁଟ ନାହିଁ।
ମୁଁ କେମିତି ସେଟା ଆଣିବି ଡିସ୍ପ୍ୟୁଟ? ଆପଣ ଯୋଉଟା ପ୍ରେୟାର କରିନାହାନ୍ତି ଟ୍ରାଏଲ କୋର୍ଟରେ, ଆପଣ ଟ୍ରାଏଲ କୋର୍ଟରେ କୋଉଠି କହିଲେ ଯେ ଦିଟା ପଲିସି ଥିଲା, ଗୋଟେ 2 ଲକ୍ଷ ଗୋଟେ 10 ଲକ୍ଷ,
ସାର୍
2 ଲକ୍ଷ ଦେଲେ 10 ଲକ୍ଷ ଦେଲେନି।
ସେଇଟା ପିଟିସନରେ ସାର୍ ଅଛି।
ହଁ ସେଟା କୋଉଠି କହିଲେ? ପିଟିସନ ଆପଣ 16 ରେ ଆରମ୍ଭ ହଉଛି, ପେଜ ପୃଷ୍ଠା 16 ରେ।
ଆଜ୍ଞା ପର- ଠିକ ଅଛି। Paragraph 10 also in my petition, paragraph
ରିଟ୍ ହାଇକୋର୍ଟ ରେ ଆପଣ ଟ୍ରାଏଲ କୋର୍ଟରେ କୋଉଠି କହିଲେ ଯେ ମୋର ଦିଟା ଥିଲା, ଦିଟା ପଲିସି ଥିଲା, ଦିଟା ପଲିସିରୁ ଗୋଟେ ପଲିସି 2 ଲକ୍ଷ ଗୋଟେ ପଲିସି 10 ଲକ୍ଷ,
ଆଜ୍ଞା
ସେଇଟା ପଚାରୁଛି ସେତେବେଳେ
ନା ସେଇଟା ସାର୍
ଟାଇମ ନାହିଁ ଆପଣ
ସେଇଟା ସାର୍ ସେ ମେନସନ କରିନାହାନ୍ତି।
ରେକର୍ଡ କଣ ଲେଖି
ଫାଇଣ୍ଡିଂ ରେ ଅଛି।
The learned counsel was requested to, the learned counsel after he made his submissions was requested to show this court where in the application before the Lok Adalat under section 22C of the LSA Act 1987, the petitioner has stated thus, and the said aspect was dealt with by the learned PLA. Para. He submits that, he seeks adjournment. କେବେ ଆସିଲେ ସେଟା ପାଇବେ?
ପୋଲିସ ଷ୍ଟେସନରେ
ଆପଣ କୋଉଠି କ୍ଲେମ କରିଥିଲେ ଦିଟା ପଲିସି ଏବଂ ଗୋଟେ ପଲିସି ପାଇଛନ୍ତି 2 ଲକ୍ଷ, ଆରଟା ପାଇନାହାନ୍ତି?
ନା ମୁଁ କ୍ଲେମ କରୁନି, ଦୁଇଟା ପଲିସିରୁ ସେମାନେ ମତେ ଗୋଟେ ପଲିସିରେ ପଇସା ଦେଇଦେଲେ।
ସେଟା ଆପଣ ଓରାଲି କହୁଛନ୍ତି ନା, ଦୁଇଟା ପଲିସିରୁ ଗୋଟେ ଦେଇଦେଲେ।
That was not the subject matter of any case, my lord.
It is submitted that
That was
it is submitted that
in respect of 2 lakhs. That
the
was
above submissions of the petitioner, learned counsel for the petitioner regarding 2 policies was not the subject matter of the
the two. Here the only case the one.
Sir, you are not reading the brief, that is the problem. When I have asked you a definite question,
I just want to.
sir, let us not, actually there is a real dearth of time. I have only 15 minutes for the entire day.
The 2 policies were there.
Sir, para 17 I have asked you to read.
My lord.
Para 17 you have answered. You can check it in the YouTube. What you have answered. So then I ask that if you are saying that there are 2 policies, one is 2 lakhs, 10 lakhs, from there we are going here and they are not getting anything.
Because 2 lakh.
You don't need to explain me. You have to simply show me that you have said that before the trial court and trial court has not ordered in finding or whatever you are not agreed with the order. I am simply asking you that what you have said. I had 2 policies. One has been paid 2 lakhs, other 10 lakhs has not been paid. So where is that in your plaint? Then you are saying that is not the case. You started saying something when the court is discussing, you are saying that is not the case. Now it is said, now it is submitted. That is not the case. The learned counsel for the petitioner has adjournment. केबे ଆସିଲେ ହବ sir?
ଗୋଟେ ସପ୍ତାହ sir.
The matter shall be listed in the week commencing 6/4/2026.
ठीक है.
ମାନେ କମ କସ୍ ଅଲରେଡି ମ୍ୟାଟର ଗୁଡାକ ପୋଷ୍ଟିଂ ହେଇଯାଇଛି, ଟିକେ ଜଲ୍ଦି କରନ୍ତୁ।
ଆଜ୍ଞା
ଆପଣଙ୍କ 23 ରେ 87 ଟା ଅଛି, 30 ରେ 61 ଟା ଅଛି, ସେଥିପାଇଁ ସେ 6/4 କରିଛନ୍ତି। We have a system of looking at how many cases are listed. Since you have become a busy counsel, you are not asking these questions, you are accepting the brief. Usually, whenever a lawyer used to come, he used to explain these things. I was called by senior advocates in Supreme Court whenever they used to. Why? They are so good. They're way ahead of me. That is how the basic struggle with the fact the order goes haywire. I was about to issue notice. When I started reading para 17, you have said something, we lost track. Now 15 minutes is wasted.
Sir, ମୁଁ ଟିକେ ଖାଲି ଗୋଟେ ଜିନିଷ ଖାଲି କହିଦଉଛି ଏଥିରେ କଣ ହେଇଛି just
ନାଇଁ ଆପଣ ଯୋଉଟା ହେଇଛି କହୁଛନ୍ତି
Sir,
ସେଇଟା ଆପଣ ଆଗ ନିଜେ ରିଡିଂସ୍ ରୁ ଦେଖନ୍ତୁ।
Court hold କଲେ
ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ ହଉଛି ଆପଣ ଗୋଟେ ସ୍ପିଚ୍ ଦଉଛନ୍ତି। Whenever I am directing you to kindly show me where you have stated and what is the finding of the court, because that is your understanding.
ମାନେ my understanding
ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ ହଉଛି ନା ଜଜ୍ ବୁଝୁନାହାନ୍ତି।
ନା ନା sir
ବୁଝିପାରିଲେ କି?
that is not
When you start, you judge ବହୁତ ଖରାପ ହେଇପାରନ୍ତି।
ନା sir
ଆପଣ ନ ଶୁଣିଲେ again ନା ସାର୍ ଜଜ୍ ଯେତେ ଖରାପ ହେଲେ ବି ଆପଣଙ୍କୁ ଦବାକୁ ବାଧ୍ୟ। Once you say that this is the pleading and this is the answer by the trial court, who is judge? Is it that judge has that much of role that he will decide what to do and what not to do? So you are struggling with the facts and the pleadings. That is the problem. You must understand where you are, in which direction you are going. So then you can, take the correct path. ଆପଣ ଯେତେବେଳେ ଗୋଟେ ଜିନିଷ you are so when you are saying that you are the claimant, your claim has been rejected. The court says yes, you have to challenge it and you have to approach the court. Now you say that the court has rejected my claim on the ground of delay.
yes limitation yes
So that has been recorded.
Yes.
Then para 17 is something different.
para 7
The 17 says that the petitioner claims that she is unaware, rustic, illiterate lady, but she has already received 2 lakhs. So how this court will overcome that of a PLA?
this court
By simply being a high court, can the high court overcome that PLA?
yes madam
You must understand.
yes there is a ground
So
madam.
that is the problem. So now when you are asked to show, then we have spent it.
The insurance
is adjourned now.
under the insurance side there is a ground madam.
ଆପଣ ସେ ଗ୍ରାଉଣ୍ଡ ଟା ନେଇ ନାହାନ୍ତି, that's your problem. କଣ ସେଟା I cannot improve it now. କଣ ଲେଖିଲେ? ଆରମ୍ଭରୁ କଣ ଲେଖିଥିଲେ? It is submitted that ଗୋଟେ submission ଲେଖି ଦିଅନ୍ତୁ, it is submitted by the Lord Counsel for the petitioner that the claim of the petitioner before the PLA was dismissed on ground of delay and laches. Yes. Next.
7
May I please, Your Lords? Your Honor, the petitioner is the husband, challenges the
Mr. M.K. Ratha for the petitioner. Yes, please.
challenges the award of maintenance.
How much is awarded? How much you have paid? What is the area? And whether you have read the law laid down by the Supreme Court.
4,000 rupees has been awarded by the
4,000 rupees since date of application
16/4/2018.
16/4/2018.
My
2026. Towards. तीन लक्ष 80,000. तीन लक्ष 80,000 अपन देलेनी केते?
I have not paid anything.
So
because
you
my-
anything?
after 15 years of marriage.
Sir, शुणन्तु आपणकर unless you read the brief and prepare the case, this will be the submission you will start after 15 years of marriage. After 15 years of marriage or 51 years of marriage, how is it relevant for adjudication in a 125 CRPC matter? Which provision? Which provision in CRPC or any case law? You have to educate me.
My lord.
Suppose I dictate that since the order is passed after 15 years of marriage, it is illegal. Correct? Can it be? Like the same thing the judge is shununanti, say he is a laughing stock. He doesn't understand what the judge is. I am considering a 125 CRPC petition.
My
Award has been made. Have you read any decision on this? Any idea? Where 125 CRPC has been dealt with by Supreme Court? Sir, देखिए, Mihir Ratha is senior than you.
My
And both
please, that
So the problem is that, like the same problem Mr. Mohanty was arguing. He emphatically argued that delay and laches, ground dismissed, my claim is not. But the court has not done that. The court has said you have already received 2 lakhs, but now you are saying delay and laches. For the lack of awareness, the problem is it's a mixed question of fact and law. Why I am giving you example? Because you can see the other. ଆପଣ ନିଜ କଥାଟା କହିଲେ ଆପଣ ଯେମିତି ମିଷ୍ଟର ମିଶ୍ର କହୁଛନ୍ତି ଆପଣ ରଜନୀଶ ବର୍ଷ ସମସ୍ତେ ଜାଣିଛନ୍ତି. Even to that extent, Odisha High Court is not strictly following that affidavit part. There are decisions. So, when you are receiving the brief, you have to tell your client that it is a money decree. Unless you secure now a money decree, the court, I will give reason that since after 15 years of marriage, it has been passed. So, I will hard issue notice and stay. Then it is a fishing expedition. When the case will be decided, nobody knows.
and the wife is also solving marital. That
Have you read
is also income marital.
Have you read? Have you read that whether it has been dealt with or not? Income of wife. Income of wife is a factor for reducing the maintenance.
Yes.
But if it is, suppose now I accept, since Mr. Ratha is saying he is sufficient, he knows the law. Since the wife's income is so much, so the order has to be stayed. Execution has been filed.
No, not filed.
Then why you are interested in pursuing? Because you cannot maintain the application. This RP revision. Then what is the scope of revision in that has been again elaborated by Hon'Ble, just one of the landmark decisions of the Supreme Court.
Because the wife has
Substantial justice has been done. The evidence has been apprised, correctly appreciated. So if you are saying that after 15 years of marriage, she is not entitled, you have to take that plea there. Let us assume that since she is married for 15 years, then what is the finding of the court?
that plea was taken, and other pleas all the pleas are taken.
So what is the finding regarding 15 years of marriage? She is not entitled because she is married for 15 years.
So far as the income of the husband is concerned, no proof has been adduced, no evidence is adduced.
Sir, that can it be a matter of speech between the conversation between you and me? You have to show the WS. You have to show me the judgment.
Yes.
What is the WS? And what the court has held up. And also read again Rajneesh versus Neha. They have said that able-bodied human being.
Page 13, internal page 5 of the judgment.
Your WS, where you have denied your liability 15 years and that you have no source of income.
Yes.
Or judge is himself is the husband.
In the judgment, it has been reflected.
WS, sir, WS, your written statement. Jabbar.
I have not understood that.
On the Podivara Tila. That was the direction I was taking you. That unless you read the WS statement, then you will make so many submissions which will fall flat on its face. Anyway, you take your seat and you want adjournment.
Yes.
The learned counsel for the petitioner was heard at length. I will pass this order because I have to go to the other. So, Kapan Kebe Chaunchanti?
Any day, your lordship, please.
Any day is not there, sir. I have asked him any day, and my lord Prijes, they are refusing to print those days on the calendar. They are starting it with 1 and ending it with 30. But these things will be mentioned that you are challenging a money decree and you will obtain instruction 3,80,000 you are defaulted.
Yes. Your lordship indicate that I will.
Okay, you obtain instruction.
Yes.
Chha chari week commencing up.
Right.
So after recess, so if any adjournments, please, because of the second half program of the bar,
item number 10. Lord, it is that case.
थोड़ा का adjust करियो से करी देबे.
No, no. Item number 10 I am kahin कहूची. Yesterday, while arguing the matter, yes, I know, my lord. Yesterday, arguing the matter, I apprised my lordship about that incident that the petitioner is serving at New Jersey and for adducing evidence is the application.
That adjournment can be sought for, no difficulty. I'll pass that order after
Evidence से close करके argument पे रख दीजिए.
Let us pass interim order adjourning the matter. So let us see. So even if you are not there in the second half, you can request your learned colleague, or I will mark your presence. No difficulty.
Second half possible.
After said that special.
No, I should sorry.
So let us see. So please do at least fresh admissions. I'll try to up to 10. I'll pass orders. I'll try to take up.
सोमवार 10 आइटम को सोमवार न रखियो कनो.
नहीं तक आज ही गला तो सेटा आपनकर ଗୋଟେ डेट नै जिबे अकोन बट आई विल पास दैट ऑर्डर दैट विल adjourn the matter.
आइटम नंबर 13.
सर ठीक देखंतु आई हैव टू गो टू द अदर साइड. आपण जोडा का adjournment चाहू चंती
डेफिट ऑलरेडी रिमूव कर.
ठीक अछि आपण सेटा त जुडिशियल ऑर्डर दरकार. आपण जे सेटा सेकंड हाफ रे मु रिज्यूम कला पर रहिबेनी ताले देखिबा कोन करे.
आथरे खाली से ऑर्डर टा कर दियो adjournment application
कर दे कर आई दैट आई विल डू. So Mihir Kumar Ratha. Step 7. Can we ask you to Mihir Kumar Ratha for the petitioner. Was heard at length. The petitioner husband in the marriage is before this court challenging the judgment dated 1/12/2025 passed by the Lord Judge Family Court Balasur in criminal proceeding number 131 of 2018. By the said judgment, the petition filed by the wife in the marriage, invoking provisions of invoking section 125 of the Code of Criminal Procedure, into bracket, since repealed and substituted by bracket closed, by so and so, bracket closed, was filed claiming monthly maintenance at the rate of rupees 25,000. The CP was favored. The petition was favored by the London Judge Family Court. However, granting a maintenance of rupees 4,000 per month from the date of filing of the application, dated 16/4/2018. On being asked, it is submitted by the London Council for the petitioner that the petitioner has remained in default of the amount directed to be paid as maintenance. In view of the judgment rendered by the Honorable Apex Court in Rajneesh versus Neha, observing that the amount awarded under section 125 of the CRC is in the nature of a money decree, the Learned Counsel for the petitioner has adjournment to obtain instruction whether the petitioner will secure the amount that has remained unpaid with effect from 16/4/2018. The total amount being 3,80,000,000. The matter shall be listed for fresh admission in the week commencing 6/4/2026. Yes. Special notice. ଆପଣ ଏଠି ସାରି ଦିଅନ୍ତୁ ସ୍ପେଶାଲ ନୋଟ ଦିଟା ବେଳେ ଅଛି ତିନିଟା ବେଳେ ତିନିଟା ସରିଯିବ ପ୍ରେସ୍ ଆଡମିଶନ yes Mr. Sahoo.
My lord, here the present petitioner before your lordship is the wife and the opposite party is the husband. Here, my lord, the present petitioner, who is the wife, filed this application under section 24 of the Code of the Civil Procedure Code for transfer of the matrimonial case, which has already been preferred by the opposite party before the family judge Bhubaneswar to the family judge Kendrapada, because on the ground that there are 3 to 4 grounds, my lord, I have mentioned in my application, my lord, that number one, that another proceeding that is for maintenance is also pending before the judge family court Kendrapada.
Sentence is wrong.
My lord?
Actually, you should always make a correct statement.
Yes, my lord. Thereafter, my lord, I will discuss.
When you stated that another proceeding is pending, are you correct?
Yes, my lord.
You should say after the CP was filed in 2025.
My lord.
The wife has filed a petition under section 126.
26, my lord.
So that you should say.
My lord, I have not received a single pie from my husband.
Can I by directing transfer, I will enforce.
My lord,
Can I by directing transfer of the CP ensure payment of 125 amount?
no, only because,
So why-
because it is
Just understand that
difficult
there is a real
for
lot of
the
time.
petitioner, my lord,
So
to
if I'll be able to record something, so there is real dot clock time because of the time schedule. So now I will suppose I direct that since she is not getting the petition should be transferred. You make a submission legally nuanced, which will help the court.
yes, my lord.
So come to that straight away.
Again, my lord.
You file in 27 or 26 a petition under section 125.
Yes, my lord.
So where is the law that this court will direct that pending petitions to be transferred whenever in future some petition is filed?
Because my
Because
lord,
neither
because
section.
DPD and my
You must, sir,
house, no income. I have not received a single pipe from
why you did not- why you did
My
not-
lord. The distance between the Kendrapada family, Kendrapada from my native place.
your client would not have heard to you whenever you ask these questions, but at least you hear the court.
Yes, ma'am.
So when did you receive the notice in the section 13 application?
13 application, my lord, I have annexed as annexure 1.
Date annexure 1.
Annexure 1, my lord, that family judge Bhubaneswar notice, that is, I have received, my lord, that annexure 1. That 10/2/2026. I have annexed annexure 1, CP 729 of 2025. They have filed this CP in the year 2025.
Okay, anything else? Anything else you want to submit?
And my
Anyway, you say the best point.
best point, my lord,
Best point is that
I'm a lady, no income. My husband is a software engineer and she is residing at Bangalore. And if your lordship will.
not he. Both of you are,
No, my lord. He is residing at Bangalore, and my lord, the cause of action that your lordship asked me on the next date, your lordship asked me to cite some decision that in matrimonial proceeding, the convenience of the wife has to be considered.
Sir,
Then
can you read the facts?
taxes, my lord,
Sir, which decision you are reading?
that in the High Court of my lord, B. Samsundar, I have had the Lord Counsel for the.
It is article 141 or it is
My lord, say matrimonial case, my lord.
अरे matrimonial my lord say court article Supreme Court decision na High Court decision?
It was Supreme Court online decision, aଜ୍ଞା.
Supreme Court decision
ହଁ
ସେ କହିଲେ
ଆଜ୍ଞା
ଠିକ
ଠିକ
ଅଛି।
ଆଜ୍ଞା ଟିକେ ତ
ଆଉ ପଢୁଛନ୍ତି କାହିଁକି ଆପଣ ପରା ବେଷ୍ଟ ପଏଣ୍ଟ କହିସାରିଲେଣି ୟୁ ଆର୍ ଏ ଲେଡି
ହଁ
ହଁ ସେ
Maybe ଏବଂ ଆଗରେ ବି କହିଛନ୍ତି in matrimonial proceeding-
ଡିସ୍କସନ କରିଛନ୍ତି 24
ହଁ 24 that this is the wife petition under section 24 of the Code of
ଆରେ
Civil Procedure
ସେକ୍ସନ
Code.
24 ରେ ତ ଫାଇଲ ହେଇଛି
ହଁ।
ସୁପ୍ରିମ କୋର୍ଟ ରେ ବି ଫାଇଲ ହବ
ଆଜ୍ଞା
ବଟ୍ 24 ଟା ଡିସ୍କସ ହେଇଛି କି
ଆଜ୍ଞା
ସେଇଟା ଗୋଟେ କଣ ଦିସ୍ ଇଜ ଦ ପିଟିସନ ଆପଣ ଆରମ୍ଭ କରୁଛନ୍ତି ଓପନିଂ ଲାଇନ ଟା
ହଁ, ଆଜ୍ଞା
24 ଟା କୋଉଠି ଡିସ୍କସ ହେଇଛି ଟିକେ ପଢନ୍ତୁ
ହଁ ମୁଁ ଏଇ ପଢୁଛି ଯେ seeking transfer of the HMOP number 89 of Swansuk from the Senior Civil Judge Court, Mangalagiri, Guntur District to Senior Civil Judge Court, Avanur Krishna Judicial District on the ground that now she is residing in her parents' house at Nagalak.
Anyway, ଆଜି ସମୟ ନାହିଁ another bench again. So ଆପଣ ସେଇଟା 24 କଥା ମୁଁ ଯାହା କହୁଛି ଏଟା ଅଲଗା ଜିନିଷ ଆଇ ଆମ୍ ସିକିଂ ୟୁର
ସେଠି କେବଳ ଯେହେତୁ ମୁଁ
ହେଲା ସାର୍ ଆପଣ ନୋଟିସ୍ କରିବାନି ଠିକ ଅଛି ତ ସେଇଥିପାଇଁ ଆପଣ
ଆଜ୍ଞା
Mr. Deepak Kumar Sahu for the petitioner. The petitioner wife in the marriage is before this court seeking transfer of the CP number 13 of 2026. Let me see. The CP कौन है? CP number 729 of 2025.
5
Pending before the learned judge family court.
Bhubaneswar.
Dash Roman 1 अपन बसी जान
Thank you.
Dash Roman 1 Bhubaneswar. Stop. The CP was filed by the husband in the marriage under section 9 of the Hindu Marriage Act seeking restitution of conjugal rights. Notices were issued in the said CP on 5th of December 2025. fixing date of appearance on 10th of February 2026. It is submitted by the learned counsel for the petitioner that petitioner wife has filed CRP number 13 of 2026 under provision of Section 144 of the BNSS. Wherein notices have been issued by the learned judge, Family Court, Kendrapada, where the petition has been filed on 30/1/2026. It is submitted that in view of the pendency of the CRP criminal proceeding number 13 of 2026 at Kendrapada, the CP filed before the CP pending before the learned judge, Family Court, Bhubaneswar should be transferred to Kendrapada. It is submitted that the petitioner is distressed. She stays with her parents at Kendrapada. ଆପଣ ଯେତେବେଳେ ବ୍ରିଫ୍ ରିସିଭ୍ କଲେ ପଚାରିଲେନି ଯେ ଆପଣ କାହିଁକି ବାଙ୍ଗାଲୋର କହୁଛନ୍ତି ଏବଂ ଆଡ୍ରେସ ଦେଇଛନ୍ତି ଭୁବନେଶ୍ୱର? ସେ ଆଜ୍ଞା କହିଲେ ଆପଣଙ୍କୁ?
ନାଇଁ after
ଆରେ ସେ ଆଜ୍ଞା କହିଲେ ଆପଣ କୋର୍ଟରେ ବର୍ତ୍ତମାନ going to dictate that. Then my factually wrong. ଠିକ ଅଛି ଛାଡି ଦିଅନ୍ତୁ ବର୍ତ୍ତମାନ. Real dearth of time. ସାର୍ 2ଟାରୁ 3ଟା ବାଜିଲାଣି. ଇଏ କଣ ଲେଖିଲେ? The parents at her parental home at Kendrapada, Para. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. Within 5 working days, list. Returnable date be fixed. आज ही कितने तारीख होची? Returnable date be fixed to 10/4/2026. नहीं 10 नो कर दियो तो 15/4/2026. ठीक है. The matter shall be listed in the week commencing 20/4/2026.
no, I have filed an IA.
Yes, yes. For that reason only ଆପଣ ନହେଲେ କଣ ଅଛି କି? हम तो सब केस डिस्पोज हो जाता है. This interim matter should not be kept pending. IA 34 of 2026 had learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. The returnable date and next date of listing shall be as above. Para. In the interim, it is directed that the CP number 7 to 9 of 2025, pending before the learned judge, Family Court 1-Roman 1, Bhubaneswar, shall be adjourned to a date beyond 27/4/2026. As would be convenient to the learned court in season of the matter. Upon prayer being made for the said purpose. Urgent certified copy as per rules. Yes, please. Next.
Hon'Ble Storage.
10,
Yeah, please. Petitioner, my lord, here he has filed one application to adduce his evidence through video conferencing, my lord. Under Annex 2 series, page 23, which has been rejected by the learned court below on the ground that the Honorable High Court is the authority to relax and direct. He cannot. He lacks jurisdiction. On that score, he has rejected the
Order is 9-2.
Yes, my lord. 9/2/2026, and he has also closed the evidence and posted the matter for argument. The petitioner is serving at New Jersey, California, my lord, USA.
Yes, but he has taken note of the fact that 10 adjournments have been granted.
My lord,
And we are breathing upon his neck. Supreme Court is breathing upon his neck. That's anyway, you take notice.
my lord.
Mr. Arijit Mishra for the petitioner, opposite party blank. The petitioner husband in the marriage is before this court, challenging the order dated 9/2/2026, passed by the Learned Judge Family Court, Bhubaneswar, in CP number 716 of 2013.
2023.
Sorry, 2023. CP 716 of 2023. Wherein the prayer for appearing through VC from her to our or his our?
Yes. Petitioner is staying at New Jersey, USA.
From his residence at New Jersey,
USA.
USA. The petition has been filed by the CP has been filed by the wife in the marriage under provision section 13.
13.
Section 13 of the Hindu Marriage Act seeking dissolution. It is submitted by the Learned Counsel for the petitioner that due to disruption in air traffic, particularly passenger flights from the USA to India through the Middle East and the adjoining countries. The flight of the you have written that the flight has been cancelled or that was
not written.
okay. There was difficulty for the petitioner to travel in time to reach to appear before the court. Para. Issue notice along with this order. Requisites for issuance of notice be filed. Issuance of notice by speed post with registration and proof of delivery be filed within a period of 5 working days. List after SR. Returnable date be fixed to 10 date कर दिया तो 15 कर लेना 15. The matters have been listed in the week commencing 28th. Para. IA 4763 of 2026. Hard Learned Counsel for the petitioner. He reiterates his submissions as noted above. Stop. It is further submitted that the petitioner shall be highly prejudiced if the matter is proceeded with by the Learned Court in season of CP number 716 of 2023. He pays for interim order of stay of further proceeding. Stop. Issue notice as above, accept one set of process fee as well as postal requisites. The requisites for issue accept the returnable date and the next date of listing shall be as above. As an interim measure, it is directed that the Learned Judge Family Court
Family Court.
dash Roman 1 shall adjourn the CP number 716 of 2023 to a date beyond 27/4/2026 as would be convenient to the court upon a prayer for the said purpose being made. Liberty to mention.
Obliged, yes.
Rest of the matter, since there is a special bench, so only the dates can be fixed. Special bench list quote ଅଛି last ଅଛି 2 PM ଅଛି ଆପଣଙ୍କର matter अच्छा then just what we can do, we can go page wise if you want any dates and all that. page 2 ରେ କୋଉଡା କହୁଛନ୍ତି 11 ରୁ 18 ଆପଣ କହୁଥିଲେ
item number
13
order complaint.
13 Mr. Sunil Kumar Patnaik, Mr. Sunil Kumar Patnaik 13 लिखନ୍ତୁ then 11 डाकी दियो तो 11 12 11 डेट कॉलेज हबो तो हां ठीक अछि डेट कर दियो 11 डेट कर दियो तो basically it is being called to for adjournment only. I mean beyond, because it is again
we consent for
कर दियो 12 पे अछंती ठीक है 12 भी अर्जेंट कर देबे 13 मिस्टर पटनायक मिस्टर सुनील कुमार पटनायक for the petitioner opposite party blank. It is submitted by the learned counsel for the petitioner that he has already removed the defects as per the stamp report. Stop registry shall verify and proceed. Kebe chahunchandi Mr. Patnaik?
6
List in the week commencing 6 yes, next please. Call apun quick huntu post kar diyuntu 15 से करथिले मेंशन ऑर्डर डका है
नहीं डका
श्योर आई थिंक ऑर्डर डाकी देली मिस्टर ये थे राजेश हैं राजेश सर मैंने से एडजर्नमेंट कोतले तापर कॉल करंतु
16 in this case lordship I am filing the certificate memo of certificate lordship.
सर एटा तो मु कोन स्टैम्प रिपोर्टर ही परिबे की I may be permitted to correct sir कुछ परमिशन की दरकार नहीं आपन को your sir your name
Shivananda Das lordship
power अछि
आगे power
so Shivananda Das 16 Shivananda Das for the petitioner it is submitted by the learned opposite party blank. It is submitted by the learned counsel for the petitioner that the steps shall be taken during course of the day for removal of defect number 9 as pointed by the SR. The registry shall do the needful for registry shall do the needful stop. Kebe asile habo
6 तारीख sir may I pray one thing lordship there is a delay in filing this appeal lordship revision may I say मतलब miscase notice may be issued to the opposite.
How can it be?
Let it come.
जो तथास्तु पावर बेपार थिले मैं बहुत किछि करि पगा तथास्तु डिफेक्टिव पिटिशन I cannot entertain. बाहर जाए कि मिस्टर साहू कहबे आगे तक मुंडो किछि काम करनी से गोटे डिफेक्टिव पिटिशन एंटरटेन कर नोटिस इश्यू कलेनी से अदर स्टेट में अपियर करियो ठीक तो सेटा तो इट मेक्स इन अ लाइटर वेट सो लेट अस नॉट बी टेक सीरियस टेकिंग अपन जेबे कहबे सेटा आसी परियो सर अपन एक्चुअली कोन आईए फाइल क्वेश्चन ना अच्छा डिफेक्ट लिस्टिंग एनी
No sir आईए सर ऑलरेडी फाइल
से लिस्ट करना सेति पाई ऑर्डर्स पे हेई परियोनी डिफेक्ट रिमूव न होले एज पर रूल्स आई कैन नॉट बी टेकन अप 6-4 कहले ना से कर देबे वीक कमेंसिंग 6-4 लिस्ट इन द वीक कमेंसिंग 6-4 नेक्स्ट
17
in item number 17 finding the affidavit that the pending in 1 lakh is
सिंपली adjourn हे जो अपन रजिस्ट्री में फाइल करन यस डेट करन तो
we consent share that
yes Mr. Raut item 18 Mr. Raut has left okay तो डेट कर दियो he was present but
मेरा चाहे
so Chinchani
My lord, item 19. This is IF for condonation of delay.
so since already time has so you take a date 19 के बेस कौन
Date 6th or 13th?
ये मिस्टर बारिक
we consent 13
13-4 ठीक है मिस्टर राउतरे has also left डेट कर दियो इनको
मेरा चाहे
items 21 to 24
23.
yes sir डेट कर दियो इनको
The last occasion, your lordship directed to serve notice through the family court Khurda. Accordingly, I had given the notice. No report has come. Only I pray that your lordship had directed that matter should be adjourned to
So,
16/3/26.
Mr. Behuria, actually, Mr. Behuria, I'm not taking up the matter.
No, only.
So 2 p.m. now it is 3 p.m. So you must understand. So you take a date, whatever orders I can pass on the next day.
And further proceeding state out ନହେଲେ 16/3 ପର୍ଯ୍ୟନ୍ତ ଆପଣ ଦେଇଥିଲେ।
Just 1 second. I have to get the file. 23 ना? କିଛି ଏଣ୍ଟ୍ରି ମର୍ଡର ଥିଲା ଆପଣ କହୁଛନ୍ତି?
ଆଜ୍ଞା।
କୋଉ ଅର୍ଡରଟା କହିଲେ? 3/2/26
ଆଇଏ ନମ୍ବର 421/23।
ଆଚ୍ଛା। The matter item 23 ଲେଖନ୍ତୁ Mr. Nityananda Behuria for the petitioner. The matter is in the list but could not be reached due to paucity of time. Stop. It is submitted by the learned counsel for the matter is mentioned. Could not reach and is mentioned by the learned counsel for the petitioner. Stop. In the interim, it is directed that the interim order as directed by order dated 3/2/2026 shall continue. Stop. It is directed that the CP number 94 of 2023 shall be adjourned beyond. Shall be adjourned beyond 13/4/2026. The matter shall be listed in the week commencing 6/4/2026. Yes, please. Call କରନ୍ତୁ. Slow down. Yes, next. ଆପଣ posting କରିବେ ଆପଣଙ୍କ ଏଇ ଅନୁସାରେ ଆପଣ ଠିକ ଅଛି। 25 to 29 କିଏ mention କରୁଛନ୍ତି?
26 in lordships.
26.
Yes, sir.
Yes, କଣ ଚାହୁଁଛନ୍ତି sir?
Sir, 6/4 କଥା ହଉଛି।
ହଉ ଠିକ ଅଛି କରିଦିଅନ୍ତୁ।
Item
27, sorry? 25?
2 after.
Yes. Adjournment is not a problem. Definitely it will be given a date, no difficult. 25 टा ଗୋଟେ date କରିଦେବେ ହେଲା।
27
25 13/4, 26 13/4।
ନା sir 6/4।
6/4 ସେ ବହୁତ ଗୁଡେ ରଖିଦେଲେଣି ସେଥିପାଇଁ କହୁଛନ୍ତି।
ତାହେଲେ 24/4 ଥାଉ sir। ମୁଁ 13/4 ଟିକେ କହିବିନି ସେ।
24/4 କରିଦିଅନ୍ତୁ। ସେ 13/4 ରେ 41 ଟା ରଖି ସାରିଲେଣି।
Interim continue.
ଆଜି ଫେର ଆଡ୍ ହେଇଛି। ଇଣ୍ଟ୍ରି ଅର୍ଡର ମୁଁ ଟଚ୍ କରୁନି।
27 ଆଜ୍ଞା
ଯୋଉଥିରେ adjournment order ଅଛି like Mr. Behuria ସେଇଟା that may be a problem but otherwise interim order I'm not touching. Mr. Sahoo 27
again I filed IA number 102 of 26. That is not tagged with the file, my lord.
So you take a date that will be tagged
Yes, my lord. Other thing, my lord.
6/4 ନା 13/4
ଆଜ୍ଞା 6/4 ପୁଟା ପାଇଛି ତଳ କୋଟ ଆଗରୁ ଡେଟ୍ କରନ୍ତୁ।
30 ଦିନ ୱିକ୍ ରଖି ଦିଅନ୍ତୁ।
Yes, sir.
27 30 ଦିନ ୱିକ୍ ରଖି ଦିଅନ୍ତୁ। ଆପଣ ଆଇଏଟା ଏବେ ରିସେଣ୍ଟଲି ଫାଇଲ କରିଥିବେ।
ନାଇଁ କାଲି ପରଦିନ ଫାଇଲ ହେଇଛି।
ହଁ ସେଇଟା ଫାଇଲ ଲିଷ୍ଟିଂ କୁ ଯାଇନଥିବ ସେଇଟା ଷ୍ଟେପ୍ସ ନେଲେ ହେଇଯିବ। ଆପଣ ମୁଭ୍ କରନ୍ତୁ। ନେକ୍ସଟ 28 29
29 ଟା ସାର୍
ଯାଇଛି 28 ବି ଯାଇଛି ଠିକ ଅଛି। ଆଇଟମ 30 31
30 ରେ ସାର୍
ଆଚ୍ଛା 31 ଠିକ ଅଛି। Yes, now call the specialist.
7/3 ରେ ଫାଇଲ ହେଇଥିଲା ସାର୍।
ଆଜ୍ଞା
ଏଇଟା 7/3 ରେ ଫାଇଲ ହେଇଛି।
7/3
Okay.
tag in. So please inquire in the registry.
May I please, Your Lordship? My lord's item 11.
11, yes.
On the last occasion, I prayed this matter be referred to the Lok Adalat. However, we have not been able to get in touch with the party.
11 ରେ କଣ order ହେଇଛି?
Yes, 6/4 yes, Lord.
Yes,
6/4 କୁ ହେଇଛି।
yes, Your Lordship.
Order ମାନେ have I dictated the order?
Order here.
So today we are simply adjourning it because the list could not be completed actually. In fact,
Your Lordship, I have intimated the DO.
Okay.
Sorry, LA officer Devgar. So I'll be letting him know again.
But Ms. Swami, you have to implement the land, the person or the authority who has benefited from the land acquisition, because they are paying the money. And the Supreme Court is very clear on this. I think Constitution bench or larger bench decision that whoever is the beneficiary of the land acquisition who pays the money compensation, he is to be heard.
So you check that, maybe in your case he has been, or you plead, because Mr. AC will ask the LAO. LAO is only the van. I mean, he is the kind of the money is deposited with him. He disburses the amount. He even cannot enforce also. I mean, court suppose wants to enforce the decree. How the court will act? The court will ask the person that who has received the beneficiary of the land acquisition. So, by the next date you obtain instruction. Yes. Yes. Specialist last year पूछे.
Item 1.
Yes. Just 1 second. Just 1 second. Yes. केबे राजी होंतु केबे कोंतु रेटे एटा ओरे टारगेट डेट थिला ना
this case my lord ready
केते दिन केबे को एटा आसीबो कोंतु
I have filed a petition for fixing a date of hearing my lord.
Any date that it is already in the hearing list.
So where to
It is today for hearing only. No, why the matter will be listed at a specific time at 2 p.m.
let this matter list
Date कोंतु ଆପଣ ଗଲା ଥର କହୁଥିଲେ ଯେ ସେ କଣ 23 ମୁଁ କହିଲି it should be early, but we never knew that this thing will happen on Friday. Yes, Mr. Mahanti, suggested date. It is posted at 2 p.m. for hearing only. 20 तारीख आज कितनी तारीख है
13
अच्छा मार्च अच्छा नहीं 20 रखंतु नहीं 19 रे रखंतु 19 18 आपण केबे कहउचंदी
May I pray for last week because
no last week there are 2 dates only. Last date केबे अछि Supreme Court directed to be disposed of.
Supreme Court directed to be dispose of the month of March by the end of March.
So how can you do it in 2 days? Cannot be.
undergone a surgery, just recovering.
Now what? Medical ground?
Maybe vacated my lord.
So how can I vacate the stay? The stay was granted after hearing you. This is not a ad interim injunction like.
Let it come on 24th, 25th.
24th रखंतु 24th same at 2 p.m. marked at 2 p.m. अपन 24th आगे जो 2 p.m. मैटर रख दीचंती ना ओके ना तो चेक करंतु काली गोटे 2 p.m. मैटर थिला सेटा केबे को रखचंती
6 तारीख
अच्छा ठीक अछि
7 से
अपन 18 रे रखु नांती अठर आग 18 देखिए so that there will be some more breathing space. The problem is that there are only 2 days left in the last week. So Mahanta
19th 18th
19th अपन चाहते ठीक है 19th रो नहीं of course she agreed for Mr. Mahanti and Miss Banerjee Pradhan, sorry, Miss Pradhan. Item 1, Miss Pradhan, Ananya Pradhan for the instructive for the petitioner, Mr. P.K. Mahanti for AC for the opposite party. Ms. Pradhan submits that the senior advocate has undergone a surgery and matter needs to be adjourned. Though the matter is listed specifically, the matter is listed to be heard at 2 p.m. marked at 2 p.m. in a special list. It is submitted by the Learned Counsel for the state that he has filed application for who application file question IA
number 23241 of 25
23241 of 2025
fixing early date
for early date of hearing. apparently, since the matter was listed before this bench on 22 Eko 2026, it was next listed. It was next directed to be listed on 26/2/2026 marked at 2 p.m. On 26/2/2026, again it was directed to be listed on 13/3/2026 marked at 2 p.m. Therefore, the prayer made in the IA for fixing of a date of hearing has already been met with, more so when a special bench has been assigned for hearing of the matter separately. Para. The Lord Counsel for the petitioners prays for the matter to be listed on 30/3/2026. Stop. It is directed the matter shall be listed on 19/3/2026 marked at 2 p.m. Yes. At 3 p.m. Kardel Habo, Mr. Mahanti.
Yes.
At marked at 3 p.m. Because again, this time, same bench, so that is how it becomes. Or it has to be assigned a separate room so that I can go to the other room so that the counsel will not be able to mention the other matters. Anyway, at 3 p.m. Second matter say 2-3. Kote order karte lebo 1-2-3 adjournment pay. Yes. Interim order dated 7/11/2025 shall continue till the next date of listing. Item 4, Mr. H.K. Mahanta for the petitioner. The Learned Counsel for the petitioner seeks adjournment in absence of his leader. Mr. Lenka, he seeks for matter to be, he makes a prayer for the matter to be listed on Mr. Mahanta. ଆପଣ 19 ଚାହୁଁଛନ୍ତି ତ लिख दियो तो the matter shall be listed on along with the connected matters on 19/3/2026 marked at 3 p.m. तेरे appearance 4-5-6 ଆପଣ
Yes, sir.
एक week in the Mr. 4-5-6 Mr. Ansuman Sethi, additional standing counsel. Interim order date अच्छी था तेरे पुराना ऑर्डर रे अच्छी देखी कर देबे लास्ट ऑर्डर टा देखिले जଣା पड़िछो यस
19/4/2024
So it is being mentioned, the interim order date is mentioned, so no difficult. Any order टा केते मु 19/4 कहि देली
नहीं मु 4 करी
March na April ଆପଣ କହୁଛନ୍ତି I could not get you actually. I am not unable to follow what you are saying.
interim order
Oh, interim order देखी करा जो. Interim order will be verified. Whatever date is mentioned, that will be mentioned. Will be checked.